So on behalf of the New York Technology Council, pleased to welcome you all here this evening for the session, Legal Essentials for Startups, Organizing the Entity. My name is Paul Ellis. I am moderating initially, but then I will just be a panelist for the evening. I want to briefly call out our sponsors. We have a large and ever-growing group of great organizations that are supporting NITech. Tonight, we want to give special thanks to Anchin, the provider of this wonderful space we're in. It wouldn't be a legal event if I didn't make a disclaimer. This is an educational event. If you're seeking legal advice, we urge you to go and consult your lawyer. But I'm really pleased to have a great panel this evening with a lot of experience working with startup companies. Again, we have Frode Jensen of Holland Knight, and then to his left we have Glen Westerback from Frankfurt, Kurnit, Klein, and Selz. I welcome them both, and Frode, with that, I will turn it over to you.
Thank you very much, Paul. I've spent a number of hours every day for the last week or two trying to distill everything I've learned about starting a company into about a 1-hour presentation. I also had to think over the last week or so preparing for this that the human beings that I've seen on a podium over the last couple of weeks are Romney and Obama, and they haven't done very well. I kept thinking I've got to do better than they do. So hopefully my ratings will be okay. So let's start. It's obligatory these days for partners in law firms to tell you a little bit about the law firm. It's the paid advertising portion of the presentation. Holland Knight, in case you haven't worked with us or heard of us, is one of the largest firms in the country. We have over 1,000 lawyers in 18 offices. And we pride ourselves in being extraordinarily value-oriented, service-oriented, innovative, and diverse. And we like to think we bring these skill sets, especially to entrepreneurs, where the range of issues is hard to anticipate, and oftentimes we find ourselves delving into portions of our firm that you would never associate with a startup, but it turns out become very relevant. I also want to point out as I start that I know there's some serial entrepreneurs in the room who've already been through this process many times. I'm basically going to pitch what I say at those of you in the room who've never done this. And so I apologize in advance to the extent that some of this is already familiar to some of you. Here's a quick slide on where our offices are. Here's a quick slide on the panel tonight, which consists of me and Glen and Paul, but Paul's already introduced us, so we can zip by that. I start the presentation with the question of when do you consider organizing a company? If every time you woke up in the morning with an idea, you ran to LegalZoom and incorporated it, you'd probably have a lot of useless corporations. Because most ideas that seem good when you wake up aren't so great by the time you have a cup of coffee and you move on with your life. If you think you've got a good idea, and if you think that it could be commercialized, probably the first thing to consider is whether you actually own it yourself. In this complex world of rules and employers and friends and colleagues and partners, it's worth considering from the start whether an idea belongs to you or to someone else. In particular, if you developed the idea on the job, working for someone else, a corporation. The idea may belong to the corporation as a matter of corporation law or common law. It also may be that you signed an employment agreement, if you're with a tech company today, where you gave ownership of intellectual property to your employer. It also may be, even if the employer doesn't own the idea, it may be that someone else owns it, and there may be a copyright or a trademark or a patent which gives someone else ownership rights in your idea. And you're not going to know while you're brushing your teeth whether there's a copyright that covers your idea. And in fact, you may not know for a long time whether your idea conflicts with somebody else's patent. But if you do know, it's a red flag that you have to be aware of. And I think we're going to cover in Glen's class all of these issues regarding ownership of intellectual property. You also have to think, am I restricted in any way from competing? Have I signed a non-compete with my existing employer or another employer that prevents me from entering the industry? So the idea may be good, and you may not have conflicting ownership of the idea, but you may have signed a non-compete that prevents you from exploiting the idea, at least if it would result in competition with your employer. And lastly, you may have signed an agreement called a non-solicitation agreement, which prevents you from working with your colleagues. And customarily, the non-solicitation agreement might be on the second or third page of a form document that you signed 5 years ago when you started work for your current employer. But upon careful review, it turns out that you've agreed not to approach the guy that you developed the idea with if he's also or she is also an employee of the company. If you get past all of these concerns regarding prohibitions and intellectual property, and you still think the idea is a good idea, then it's time to go and organize the company. So the first thing that a lot of entrepreneurs do is imagine that they've got a great idea and start collecting the profits immediately from exploiting the idea. I don't know whether there are any South Park fans in the room, but one of my colleagues brought this slide to my attention, apparently in South Park a few episodes ago. The idea was to collect underpants and write a business plan and start making profit. Well, it's a little more complicated than that. Here's a slide that shows the lifespan of a business, and it starts at 12 o'clock with an idea and ends at 11 o'clock with an exit. Now, exit historically in America, or historically in business, was the death of the founder, because until very recently it was hard to transfer businesses. I say very recently, meaning in the last decades. And typically businesses were organized as family partnerships, and they grew or didn't grow and expired upon the death of the founder unless there was a son or a daughter capable of taking on the business. Today, businesses have very definite intervals of lifespan, and there are different stages and different approaches to managing and growing a business, and there is very definitely a potential exit. So what we're talking about today is starting a business properly so that you set a good foundation so that the business can be expanded without unexpected risk or unexpected dissension or unexpected legal problems, so that the business can optimize and ultimately, presumably, be sold. So how do we start up? What's the trigger event? It's often, well, in brainstorming for this presentation, we thought about a lot of trigger events, and it's hard to write a black line rule of thumb as to when you should organize. When you start spending money on the project, think about organizing an entity. When you become convinced that this great idea could actually be commercialized, start thinking about forming an entity. Especially if you are talking to friends who might be partners, think about organizing an entity. If there are co-founders, if you share the idea with another person, think about organizing an entity. And even if none of these factors is a major factor yet in your mind, realize that you are incurring liabilities in your own name as you get to the trigger point, which you may not be able to avoid or transfer to a corporation. So think about organizing an entity from the very beginning, and then do it as soon as one or more of these factors becomes serious in your mind. We all, the lawyers, we're all three lawyers on the panel. We all have experience with entrepreneurs who come in too late to organize an entity. Sometimes they discover this employment agreement problem late in the process that might have been negotiated away. Sometimes they've entered into a contract and there are liabilities associated with the contract, and it's too late to limit those liabilities by putting the contract into a limited liability entity. In terms of commercializing the idea, don't underestimate the amount of time and effort and thought that goes into organizing an entity at the same time that you're commercializing the idea, that you're developing your idea. This is sometimes hard to do because in the entrepreneur's mind, the most important thing, the only thing, is the idea. And everything around the idea, including putting it in a nice home with a corporate name on it, is a distraction. It's something that the entrepreneur often doesn't get to. But I'm here to say it's important to retain advisors, to do the work, to make the decisions, and to set the strong foundation in place. The last sentence in this slide is important. Liabilities arising before incorporation generally cannot be erased by subsequent incorporation, meaning you can't enter into a contract in your own name, which has obligations on your part, and then assign it to a corporation and believe that your obligations are extinguished and they become corporate obligations. No, they remain your obligations. And so, for example, contracts with service providers, suppliers, R&D, consultants, et cetera, all of those types of initial agreements that you might be inclined to enter into, if you do it in your own name, remain in your own name.
Frode? Yeah, I'd just like to jump in on this one for a moment because it's so important. I think it's an issue that I see with a lot of my clients is there have been several instances with clients that I had that came to me after they had started a business. They had an idea. They went out. They began to develop the system. They maybe had a partner. Maybe they were doing it on their own. And notwithstanding the fact that they had a good idea, a good system, a good technology, because of problems in the way that the company was put together, very often problems among the co-founders that hadn't been properly sorted out in a shareholders agreement or an LLC agreement, the company failed. And it failed not because it wasn't something that could have been successful, but it failed because the company hadn't been properly put together in the first place. And by the time they came to me, we couldn't really fix it anymore. You had, the founders, they had disagreements on what the ownership percentages were, what the rights were, whatever. Maybe they had a disagreement among themselves. They couldn't sort it out. So I think it's something, as Frode says, you need to take the organizational structure very seriously, because it can sabotage what would otherwise be a successful business. Glen?
Yeah, and I would just add, from a IP perspective, it's certainly useful and helpful to make sure that you have the entity formed, so that as employees are creating new work product and as vendors are building things, whether it's your website or it's your product or service, you want to make sure all that IP is owned by the entity. So the sooner you take care of organizing it, the sooner that aspect is hopefully taken care of. And then of course before you hire employees, companies typically like to have an entity from which they're going to be hiring the employees. And also before you launch your product or service, just to make sure that the relationship with your customers is one where your liability is going to be limited with them.
We could probably go off on war stories, and I'm tempted to. Paul and Glen remind me that one of the things that happens in the idea stage is that there is often talk among a partner and a potential co-partner, or a founder and a co-founder, or an employee, and the talk often involves percentage ownership. If that percentage, and that is often can be the most sensitive issue, and if that discussion is deferred and never documented, our experience is it becomes virtually impossible to document it after the fact. Positions harden, differences of opinion arise, and what is always a difficult discussion becomes an impossible discussion. So let's turn to possible structures. Let's assume that you've decided, you're persuaded that your idea is good enough to organize an entity around, but what kind of entity, and in what jurisdiction, and why? You've heard about LLCs and you've heard about C Corps and S Corps. Well, which one do you choose? Here are some of the basic elements of these different structures, so that you have, so that you can have in your mind the differences between the structures, and as you develop your idea, you can think about which structure might make sense. Ultimately, you'll end up discussing structures with an advisor, with a lawyer, and you'll pick the best structure for your idea, for your ownership structure, for your capital structure, and for your tax situation. A lot of what we're going to talk about is tax oriented, and I'm not going to go into the tax details in to any great length, but I'll sensitize you to the tax issues that exist. For purposes of this discussion, there are 4 types of structures. There's the sole proprietorship, there's a partnership, and there are different kinds of partnerships. There's the LLC, and there's a corporation. You can't even call these entities, because a sole proprietorship is not an entity. A sole proprietorship is what any one of you are if you don't organize a company, but you engage in a business. You are then, by default, engaging in a sole proprietorship. I've got a slide on that. I guess it's a couple more down. The other 3 are forms of entities. The reason to organize an entity, I've touched on. The primary reason probably is to limit liability. We live in a dangerous world. There is liability after you wake up with your idea and get dressed and step out the door onto the subway. There is liability, and there's liability all day long. The corporation and the limited partnership and the LLC are marvelous inventions of modern, going back 100 years in some cases, but modern legislatures to promote the operation of businesses with limited liability. It's a hugely important thing because it allows entrepreneurs and business operators to manage the extent of the risk that they want to take in connection with any given idea. If we didn't have a limited liability entity, and we had businesses taking risk every day, which they do without limitation, then bankruptcies would be devastating. They would be impossible to recover from. There would be no, I'm exaggerating a little bit, but there would be no reconstruction of companies through bankruptcy. Limited liability, when you think about it, is a very important tool in operating a business and operating a capitalist system. Other aspects that are important to consider in organizing an entity include creating an entity to manage the accounting of your idea separately, creating an entity in order to ensure that you pay the minimum amount of tax that you owe under the system in connection with expenses that you incur, and then hopefully profit that you may generate if the idea proves profitable. You need an entity in order to attract any kind of third-party funding, even if, well, the first element of third-party funding is when you go to your friends and family for a loan. That's third-party funding. When you organize an entity with a partner and one of you puts in $100 in an idea and the other one puts in $10,000 capital, that's third-party funding. And you really need an entity to accommodate the issues that arise when there is an idea that attracts funding. A corporation also gives you credibility, or an entity gives you credibility. You can be an individual with an idea. An entity that houses the idea shows that you've given thought to building the idea, to building it out. As Glen mentioned, intellectual property, it's very important to have an entity to control to manage and protect your intellectual property rights. And then lastly, you really can't accommodate employees, and you really can't offer incentive compensation without an entity. So when these elements of your business plan become important, that's when you have to consider organizing an entity. And then lastly, when we think about this, I think there's a benefit in tidiness. There's a benefit in pulling all of these strands together and making sure they mesh properly. And to the extent that the strands aren't pulled together, our experience is they pop up at inopportune moments. And you have to either backtrack and spend more than you would if you organized up front, or you discover that there's a fatal problem and either the idea won't go forward or the ownership is so hopelessly tangled that you have to stop work on it. This page is a summary of these concerns. I think I've touched on them. I want to do a shout out. I don't know whether there are any accountants in the room. I don't know whether Anchin is here. If you are, put your hand up. Thank you very much again. But it's very important to get your books set up. With technology today, it is so easy. You don't need shoeboxes anymore. It's so easy to have accounting systems that that will segregate your idea and the expenses that you're incurring in developing your idea from the rest of your life. Another issue that an entrepreneur faces at the very beginning is, oh my God, there are all these expenses. I'm gonna have to pay an accountant. I'm gonna have to pay a lawyer. You know, we'll come to that. I'll get to the lawyer question. But I think what we want to say on behalf of the panel is that increasingly in the startup world, there are lawyers and accountants who get it, who understand the problems that entrepreneurs are facing. And there are lawyers who, not only lawyers and accountants, who will help the process, and there are fee structures that that reflect the expertise of these professionals. So don't avoid talking to an accountant, for example. Okay, so now I'm going to go into a little deeper dive on the forms of entity. They are sole proprietorship, partnership, LLC, and corporation. These are the four basic choices that are out there. There are other entities like trusts. You can have business trusts. There are real estate investment trusts. There are limited liability partnerships for service corporations, for professionals. But the four basic categories are the ones I mentioned. As I said, if you do nothing, you will default into a sole proprietorship. Sole proprietorship it's not an unacceptable way to do business. I suppose the individual guy who's a plumber and doesn't bother to incorporate and just hangs his shingle out as a plumber is a sole proprietor, and he doesn't enjoy the benefits of limited liability or tax planning or any of the other things we've talked about, but you can do business that way. There are some benefits. Sole proprietorships in general don't have to be registered, although a lot of businesses are subject to state and local licensing. So you have to consider, even if you don't organize an entity, whether there's a license. And a lot of technology businesses, which on first blush are technology businesses, on second blush are regulated. And the fit may not be perfect, but there may be a need to comply with state and local business license regulation. For example, we see it with software companies that are providing services to financial services firms. And you may think that you're simply a software provider. It may turn out that you're a broker-dealer. And there are dozens of examples where technology companies that are providing services to businesses that require licensing end up being subject to that licensing requirement themselves. There are no advantages in a sole proprietorship. There are no tax advantages in a sole proprietorship. All of your income and your expense is simply goes on your own 1040, and you pay tax without the benefit of any pass-through rules or other corporate taxation benefits. We don't recommend a sole proprietorship. The second category is partnership. You know, it used to be that businesses were generally organized as partnerships when, in the beginning, corporations had to be approved by legislatures, and corporations are creatures of legislative act, and then subsequently there were corporation statutes adopted. Now it's easy to form a corporation, but in the beginning it wasn't, and people did business as partnerships. It's through partnerships and limited partnerships that the concept of limited liability arose. But today it's very unlikely that you would want to be a partnership, and it's very unlikely that you would want to be a limited partnership. Now, there are businesses that still use the limited partnership structure. For example, the hedge funds and private equity funds that are in venture capital funds that hopefully you'll be interacting with at some point are often structured as limited partnerships. And it's a structure that works for passive investing. It's pretty unlikely it's going to work for an active business idea that one of you may want to promote.
Frode, I just want to jump in here on one point, which I think is important. Frode mentioned and it was on one of the previous slides, if you have multiple founders and you do nothing, you don't form an entity, then you are a general partnership. And that doesn't generally happen by design. It happens because you're not really paying attention. But it's important to realize what the implications of that are. You have a founder, you have a partner, or call him a partner. You guys are working together. You've got an idea. You start to build it. You develop some technology. You're thinking this is pretty cool. At some point we need to get that entity formed. We need to do something about that. But we're too busy too busy getting the thing going. If anything happens along the way at that point, since the courts would likely deem that you are a general partnership, which means that you are each fully personally responsible for the actions taken by the other person. And I think that's where you really want to pay attention, because it's one thing when we say in the sole proprietorship, if you screw up, you don't have a limited liability entity, okay, you're on the hook. That's your bad. But now you really compound the problem. If you have not formed an entity, if you've got a co-founder, you're found to be a general partnership, and then your partner screws up, and you're on the hook. So I think that's, again, one of those things, it can be a gotcha and something people should be aware of.
That actually brings to mind another thought, which is from one of the earlier slides, when Frode mentioned you should make sure you're not subject to, non-solicitation or non-competition agreements, and that you the idea that you had is not owned by your employer somewhere. But it's sort of an issue here where if you are considering starting a company with other founders, you have to worry about what are they subject to. Because if your founder is working for, Microsoft, and he just came up with an idea, you should probably ask him to see if he could share his employment agreement with you, so you can make sure that the idea he's proposing for your new startup together, is not something that's owned by his employer.
And which you have liability for potentially, because you're still a general partnership. So,
if your partner goes out and agrees with a vendor to purchase equipment for $20,000 and then defaults, and you're a general partnership, you're liable. You don't want to be a general partner, not for very long. So this brings us to, this is Paul's slide. It's a great slide, I think. You've all heard a lot about the limited liability company. They were developed in the 80s. I'm going to say the first statute was in Delaware. I think that's right. Yes? Wyoming? In fact, okay. But popularized in Delaware, and it was the 80s, I think, early 80s. What a great structure. You get the benefits of a corporation without the limitations, the rigidity of a corporation. An LLC is an extraordinarily flexible device to use to house an idea in a business. But the problem is, especially at the startup stage, is there's so much flexibility you can get bogged down and find yourself with too many decisions to make. It's a close call, and there are other considerations relating to whether you pick an LLC or a corporation. But I loved it when Paul said the other day that the real problem is, the real benefit is so much flexibility, the real problem is so much flexibility. So we put it in a slide. An LLC is an entity which it's in fact not a corporation. It's a company. It's a creature of law. It really acts like a partnership, but it's not. It's a company. It's created under the LLC statutes of the various states. It provides two very important things: limited liability, which means that the members, who are the analog of the shareholder in a corporation, are not liable for the debts of the entity. So they have limited liability. The only liability is for the amount contributed to the limited liability company. And also a limited liability company, and this was extremely important in the beginning, maybe slightly less so today, could elect pass-through treatment, meaning it was taxed like a partnership. It didn't pay entity-level tax. That meant that expenses and income are passed up to the members without corporate income tax being imposed. And you know, there's a big debate today about how much, what the corporate income tax rate should be. It doesn't apply to LLCs. In general, they pay no tax. Since Wyoming established the first LLC statute, I think there are now LLC statutes in all 50 states. They're all slightly different, but they all work the same way. And they, as I've been saying, they have enormous flexibility. The main area of flexibility is that membership interests, ownership interests in LLCs can be sliced and diced with non-pro rata allocation and distribution provisions in order to benefit members disproportionately. You can't do that in general in a corporation because every share of stock is a fractional undivided interest and has the same rights as another share of stock. It's not true in an LLC. And there are many business situations where the slicing and dicing those rights turns out to be a substantial benefit. There are also many situations where passing through expense at the early stage of a startup to the investors is a benefit, whereas in a corporation, the expense cannot be passed through for tax purposes. These are the primary benefits of LLCs. There are other benefits too. You're not stuck with a board and officers. LLCs really function by contract and by agency principles, and anybody can be named to manage an LLC, and the rules can be hand-tailored. You don't need a formal board. You don't need a certain number of directors. You don't need to follow the rules relating to board meetings. For example, there are corporation provisions and statutes relating to how many days notice you have to have for a meeting and whether or not the action is recorded in the minutes. And none of these things are necessarily mandatory in an LLC. However, there's a big problem with LLCs, and that is, or a substantial problem, that is that venture capitalists prefer corporations. They prefer corporations for one basic reason, I think. There are probably a lot of reasons, but the first one that comes to mind is the fact that it's tougher to use a preferred stock structure in an LLC. You can do it. You can actually mimic almost anything in a corporation in an LLC with drafting, but it gets complicated and expensive. A corporation is a structure that investors, venture capitalists, entrepreneurs understand, and the elements of preference that are involved in preferred stock are easier in general to implement in a C corporation, which is a taxable corporation.
Yeah, well, you were probably going to go to this. It's also the pass-through. Most VCs aren't going to want the pass-through taxation.
Right, and there are actually reasons that aren't on the slides. Let's see, the next slide is, well, here are the elements of limited liability companies. And I think where Paul was headed is some investors really can't invest in LLCs because they aren't taxpayers themselves. They may not be U.S. taxpayers, or they may be pension plans or defined benefit plans or universities or other charitable institutions that are not taxpayers. And an LLC which passes through taxable income is anathema to those investors. But for lots of reasons, venture capitalists don't like LLCs. So there's kind of a judgment call in the early stages about whether you're better off with an LLC and the elements that I've talked about that are beneficial in an LLC, or whether you're planning for venture capital investment. Of course, the venture capitalist is going to drive a tough bargain, and a lot of entrepreneurs would just as soon avoid the VCs for as long as they can. And it's hard to know on day one which structure is going to work better. But I think in our discussions with Paul and Glenn, we agree we're seeing more and more LLCs at the early stage. Do you guys want to comment?
Yeah, I think within our office, we're seeing more and more companies choose the LLC form, because there's a certain simplicity that's associated with the flexibility of the governance of the organization, because you can essentially start a company with 1 or 2 people, have a 10 or 12 page operating agreement that sets out what each party's respective ownership is, how the company is managed, and whenever you have questions about any of those things, you can just refer to that, and it's fairly simple and straightforward, and you don't have to worry about, oh wait, when do we have our annual meeting, or what has to go in the minutes of the corporation. So a lot of companies, especially those that think that they have an idea which they can self-fund, and which maybe they don't even plan on looking for VC funding, they're attracted to that. But a lot of serial entrepreneurs who think that they're going to really do serious fundraising would certainly probably go down the route of forming a corporation.
Well, yeah, I would just pause on that, the question that Frode was talking about, the investment, because that's really, that is where the rubber hits the road for a lot of people. If I start as an LLC, I want VC investment, what am I going to do? As Frode mentioned, that the conventional wisdom has been that VCs are not going to invest into an LLC. Things are changing. We all are seeing situations where VCs will do an investment into an LLC. In addition, as many people know, converting an LLC to a corporation can be done relatively simply. I mean, there is some cost involved in terms of legal fees. Depending on how much complexity has been introduced into the structure, that may introduce additional cost. But converting from an LLC to a corporation certainly can be done. You can go the other way also, from a corporation to an LLC. However, there are significant tax implications for doing that. So I think what I'm seeing is that increasingly startup companies, they will consider forming as an LLC, knowing that when the time comes, if they need to, they can certainly convert to a corporation.
Which probably is a good segue into the next slide. There is one serious downside on LLCs in New York City. It applies to partnerships and LLCs, and that is there is still on the books in New York City an unincorporated business tax that basically takes another 4% of taxable income. And if you use a corporate structure, or if you check the box to be taxed as a corporation, you're not liable to this New York City unincorporated business tax. This was just, I can't resist a little history here too. This was a tax that was implemented back in the day when all of the stock brokerages and investment banks were partnerships. And it was just a way, and since they had to have their offices south of Houston or Canal, one or the other, back in the day, near the stock exchange, New York had captured group of partnerships, and they applied an extra surtax to them. Now, today, none of the stock brokerages or investment banks are partnerships, but the tax remains, and it's applicable to accounting firms and law firms.
So the lesson is have an address in Westchester.
And have your taxable income allocated to Westchester, right? So that's the story. That's the very short and quick story with limited liability companies. So much flexibility, both ways. So, corporation is the format that you're familiar with. Corporations in general are taxable entities. They're subject to federal and state corporate income tax, and they are legal persons. They have all the benefits of limited liability. There is a set of rules that you have to adhere to get limited liability protection, and these are called the piercing the corporate veil rules. But if you properly organize the company and capitalize it and operate it, it will have limited liability, and you'll get the benefit of the corporation. There are two kinds of corporate structures. There are C corps, which are taxable. There are S corps, which have pass-through. I'm going to pretty much skip over the slides on S corps. There may be situations where an S corp is still a useful structure for an entrepreneur. It does provide a corporate. You can have a corporate as opposed to an LLC structure and get the same pass-through treatment that you would have with an LLC. But there are rules and limitations, and there are also problems at exit with S corps, including taxes that have been deferred that all of a sudden come due. There are some compliance issues. And if you give Paul or Alice your card and we send you this slideshow, you'll see a table that summarizes everything I've said.
So Frode, I think what's sort of the takeaway here with respect to LLCs and corporations is that yes, there are. We have this issue with investment for VCs, whether they're going to want to invest in an LLC, but there are significant advantages to the LLC form. There's the pass-through taxation. If you never have to convert and you're an LLC when it comes time for an exit, there are, depending on how the exit is structured, there are potentially very significant tax benefits to being an LLC at the time that you sell the company. There's the flexibility that Frode mentioned. So there are a lot of good reasons to be an LLC. The investment is one that you need to deal with. There are ways to deal with it. So I think it's, this is something we were discussing. The conventional wisdom is if you're a startup company, you should be a corporation. That is shifting, and at the end of the day, you want to. It's something you really need to speak about with your lawyer, speak about with your accountant, weigh the different alternatives, so you make sure that you're making the right choice.
And one thing that I think we have to mention with LLCs for New York is that if you're forming an LLC here, New York does have a publication requirement, which is actually quite expensive. If your address is in New York City, it could cost about $1,300. So it's one of those laws that unfortunately founders of companies that don't yet exist don't have a lobby group in Albany to work for them, but it's something to be aware of.
Did you have a question?
I'm just curious, like on a percentage basis, how you would thinking about corporate formation, what percentage of the last 200 startups that you guys have worked on were C Corps versus LLC versus some of the other alternatives? Just directionally.
Yeah. I think it's very sui generis. It depends on the facts and circumstances, but it's probably 50-50 or getting close to it.
I would say it's probably it's at least half are LLCs these days, more than half. And I think I read that in Delaware they're forming more LLCs and corporations at this point. So which is a telling point, which is perhaps a different issue than for the technology startups that we're talking about here, because if what you're forming is a dry cleaner or something like that, then it's going to be pretty much a no-brainer that an LLC makes more sense. But nevertheless, LLCs are becoming a very popular form.
So the observations Paul just made are summarized on this page pretty much. Let's move to where to incorporate. We could spend a lot of time on this. Did you have a question?
Yeah, sorry. Are
LLCs as a startup, are LLCs able to operate or do business outside the U.S.?
Yes. Whether or not they want to for tax purposes is another question, and where they want to generate income is another question. But in general, a U.S. company, it may have to qualify abroad. It would frequently organize a subsidiary to operate abroad, but it could sell abroad without difficulty. So where to organize? The overwhelming preference of lawyers and investors is Delaware. I have some slides that go through the alternatives, and you can, there are a few decisions to make, and maybe the choice used to be a little bit tougher, but I think for a lot of reasons the place to go is Delaware. Delaware, if you do go to Delaware and you're not operating in Delaware, you will have to qualify in the place that you operate, at least when you are engaging in a trade or business in that place. And that'll involve a slight additional cost. For example, on this slide, it's about $225 more to qualify in New York if you've organized a Delaware company. And then you have to pay an annual fee. In general, in picking a jurisdiction, you think about the fees associated, the level of service that is available in the state, the recognition factor, that's where Delaware is very strong. Predictability, which means do you know what you're getting into? Are the laws frequently litigated? Do lawyers know what the laws mean? Are the statutes updated so that they're so that new developments in the law are facilitated by updating the statute? In general, the geographic location of the business doesn't matter. You can be operating in New Jersey or Connecticut or New York and incorporate in Delaware. And your income tax is going to largely be, when you get to that, when you go income positive, your income tax is going to be a function of where your office is, not where you're incorporated. So the choices boiled down for purposes of this discussion are Delaware, New York, and the rest. I'm going to flip through to, here's a slide on Delaware which shows how popular it is. There are 900,000 business entities organized in Delaware. I was reading an article this morning about how dependent Delaware is on its corporate organization business. 17% of Delaware's budget is covered by corporate franchise tax. I mean, that number couldn't be 1% in any other state. It couldn't even be a fraction of a percent. So this is a big business in Delaware, and interestingly, it's a risky business because when a big company gets merged out of existence, Delaware loses a whole bunch of franchise tax. And this is an incentive for them to keep updating the statute and making it user-friendly so that new companies keep coming in. And occasionally, a state will decide that it wants to compete with Delaware, and Nevada has positioned itself as a West Coast Delaware alternative, and there's some elements of the Nevada statute that are attractive. And I think there was an effort in North Dakota to create a Delaware-type business, but they really haven't gotten off the ground. Delaware has invested so much in, I'll go to another slide, has invested so much in its system. The corporation law is friendly to business. It has appropriate protections for officers and directors. It's flexible and modern. There is a court in Delaware that is 100% dedicated to hearing corporate cases, and not just the big ones that you read about in the paper, even small ones involving technology companies that end up in disputes, end up in the Delaware Chancery Court. There's nothing like it. There is a commercial court in New York that is an attempt to provide, business-like solutions. It's nothing like the Delaware Chancery Court. The state legislature, because 17% of revenues depend on a statute that operates, is constantly updating the statute, and the Bar Association is totally invested in keeping the statute modern. And then the Secretary of State's office runs like a tech company. You file electronically, you can get questions answered electronically. They accept filings around the clock, and the staff works till midnight. So there really is no state that is operating and of course that is operating a incorporation system like Delaware's. Of course, there's also a federal challenge. Remember, the reason that Delaware incorporation exists is because we have a federal system, and traditionally corporation law has been a matter of state law. But with Sarbanes-Oxley, with Dodd-Frank, there are federal incursions, and some observers wonder if we might be moving toward federal corporation laws. That would be a terrible development for Delaware. Here's a slide that shows how the costs stack up. An LLC, you can see, has modest costs. Corporation has modest costs. The franchise tax of $75 could go up to $180,000. That's the max, but don't fall off your chair. The tax is essentially $340 per $1 million of assets or par value. So when you're starting up a company with $1 million of stated value, par value stock, the tax is $340. If you had $1 million of assets, in this example at the bottom, the tax would be $1,400. That gives you an idea, order of magnitude of what you're facing in Delaware. People do organize companies in New York. There's nothing wrong with the New York corporate statute. Venture capitalists don't like it as much. Lawyers like the three of us don't like it as much. The New York statute is tougher to deal with, and there are quirks in it that make it less flexible. But if there are reasons, including local reasons, including maybe you're taking money from a New York state agency that wants you to be a New York corporation, there's no reason, there's no really good reason why you shouldn't do it or couldn't do it. You also might be inclined to incorporate in the home state if your business is in New Jersey or Connecticut. New Jersey and Connecticut have perfectly good incorporation statutes, but again, unlike Delaware, they're not kept up, they're not as flexible, they're not as modern. If you don't think you're going to be attracting venture capital, if you don't think you're going to be operating out of the state, if you don't think you're going to have to qualify in another state to do business, and you think your business is limited to, for example, New Jersey, you can organize in New Jersey, you can form an LLC or a corporation in New Jersey. And there are others. I list two here, Nevada and California. California does have some quirks which California venture capitalists are quite familiar with. And if you run into a California venture capital firm, they'll probably advise you to stay away from California. There's also, to your question, there's also the question of foreign incorporations. You've all heard about Cayman Islands, Bermuda, British Virgin Islands, Singapore, Hong Kong incorporations. These things largely become relevant if your investors are offshore or if you have a tax strategy that involves savings that could be obtained through using an offshore corporation like Governor Romney has. But there are very legitimate tax savings to be obtained from placing assets offshore and operating offshore when it's appropriate. And that's probably not an early stage concern, but it can become a concern if the idea is successful and there are sales abroad or intellectual property abroad or assets abroad. So, we get down to the last. I apologize for rushing a little bit, but we knew we had a lot to go over. So if you have an idea and you've decided that it's worth protecting by creating a corporation to house the idea. Creating an entity, and you've consulted, you've read through these slides again, you've talked to lawyers, you've gone on the internet, you've decided that it's going to be a Delaware corporation or a Delaware LLC. Then what are the issues that you have to deal with next? If it's a corporation, there's a name issue. Well, frankly, there's a name issue regardless of which entity you choose. There's also a decision to be made about whether you have one class or more classes of stock. You have to think about management, meaning is there going to be a board of directors? Who's going to be on it? How are the voting rights going to be sliced and diced? There are going to be officers. Who are going to be the officers? What are going to be their titles and responsibilities? The same thing is largely true for an LLC. It's just that the structure is different, as we've discussed. The name, frankly, can often be a real problem because the name has to be available not only if you choose, for example, a Delaware corporation. The name has to be available in Delaware, which means that it has to be a name that the Delaware Secretary of State doesn't think is confusing or conflicts with somebody else's name. It has to be available in the home state because you have to qualify to do business in the home state. It has to have words of limitation that you like. So if it's going to be Acme Widget, it has to be Acme Widget Corporation or Incorporated or Inc. You have to be consistent in the word that you use. And then you have to worry about whether Acme can be trade name protected around the rest of the country, because you don't want to wake up and discover that, well, I organized in Delaware under Acme and I got qualified in New York under Acme, but in California, you can't sell widgets using Acme in the name. So,
Frode, I would just add to that list, you also want to check if the domain name for that name is available.
Yes, absolutely. And that, as you probably everybody in the room knows, your first choice of domain name is always gone, right? And you can't avoid that by choosing a corporate name, which might be available.
Yeah, and that's, that doesn't need to be, you don't need to use the same domain name as you use the corporate name, but it certainly is part of your branding strategy. It is important to think through these issues in the beginning, and in a sense, we're looking forward to an issue that we'll address in the IP segment when we get to that in a future session. But in the beginning, you want to think, what's the name of my entity? How am I going to brand my product? What's the domain name that I'm going to need? Is it available? Speak with an IP lawyer in terms of trademark protection, so that as you start to roll things out, that as you start to use a name and invest time and money in branding a name, that it's a name that you can use, it's a name that's defensible, and so that you can really achieve your objectives.
Right. For example, if you picked a name that was, Glen sells water bottles, for various trademark related reasons, that would not be a very strongly protectable name, while a name like Exxon would be very, very protectable if that was your original idea.
Because of its uniqueness.
Yeah.
Yeah. So we have a client that chose a name that was available in Delaware and New York, and after building the business for a couple of years, discovers, I'd say 2-3 years in, that there is somebody else doing business in his industry with a very similar name. What a terrible situation to wake up and discover that you're in, because you've spent all this time and money on branding and marketing. And in this case, this other entity hasn't complained yet. We haven't gotten, what do you call it, a cease and desist letter? It hasn't come yet, but it's always out there, and investors are going to be reluctant to invest in a company that is sitting there with a potential cease and desist. Yeah.
On the other hand, Jerry Spiegel and your firm helped my company, which was called BlackBerry Technologies, and for many years we went merrily along. Right. And then in 1995-96, BlackBerry that you guys all know got interested in our name and eventually had to buy our domain. So there are two sides to this equation.
Good point. I hope everybody heard that. I think this is virtually the last topic, and I'm going to hit it pretty quickly, but it's important. It's very important to think through governance and stock transfer, membership interest transfer issues at the beginning. It's very important to think about who controls the vote in the corporation. It's very important to think about who breaks ties. Very important where you have partners to talk this through and get it written down and sign the writing. It's very important to put transfer restrictions on the stock. You don't want to wake up with a new partner because your old partner sold his interest to somebody you don't know. Frankly, this is becoming a serious problem with estate transfers in the private equity industry, where private equity founders are dying and the stock is ending up being distributed to wives and children who aren't working in the business. And oftentimes there were no transfer restrictions because some of these partnerships go back a number of years. People weren't thinking about that. And it's very important that you think about exit rights. Who can force a sale? Who can prevent a sale? And if a sale arises, who participates in the sale? These are very tough things to think about when you're really trying to commercialize your idea and stay afloat and get to market. And some lawyer is telling you, well, you really got to think about, you might want to be selling down the road and you might have a disagreement with your partner and you got to have a tiebreaker resolution. But our recommendation is very strong that these are issues that should be confronted up front and documented, and life turns out to be a lot easier if there are agreements.
Yeah, I want to add something here, because a lot of what we're doing up here is in the nature of issue spotting. We're sensitizing you to issues and things you need to think about. We can't necessarily give you the answers, but we can sort of flag them so you know to think about them when they come along. To me, I would say this slide here, number 56, governance and transfer issues, is probably one of the most important slides in this whole deck. And I say that because when I look over the years I've been in practice, and I alluded to this before, one of the biggest problems that early stage companies have is when they fail to sort out governance issues among the founders in the beginning. And I would tell you that over the last year, I've had 3, maybe 4 situations where a group of founders or someone came to me after they had formed or not properly formed their company, had some type of dispute or misunderstanding or uncertainty, and had huge problems. In one instance, it was the end of the company. The company didn't survive. In fact, I've had 2 companies, now that I think about it, over the last few years, where they didn't have a proper shareholders agreement or didn't have a proper LLC agreement, and a problem came up, and there was no effective way to deal with it in the agreement, and as a result, the company failed. I've had another situation over the last couple of years when a couple of founders, they tried to form on the cheap. The agreement was not well drafted. They had a dispute. They came to me. They said, "How do we?" Or one of them came to me and said, "It's just not working out with my partner. What do I do?" And I looked at the agreement and said, there's virtually nothing that you can do. Your only choice is to basically to dissolve the company. So you have 2 choices. Either you negotiate something with your partner or you dissolve the company. Now, if they had come to a lawyer in the first place and gotten a proper LLC agreement or a proper shareholders agreement, there would have been a buy-sell right, or an arbitration provision, some type of tiebreaker, something in there that would have provided a way that they could sort out a dispute after the fact. And as Frode alluded to, if you don't get these things sorted out in the beginning, when everyone's on the same page, when everyone's in agreement, after the fact, once there's a dispute, there's it can be impossible to sort it out.
How does dissolving the company, assuming one of them can do that unilaterally, how does that solve who owns the IP?
Well, I mean, among the alternatives we discussed was to dissolve the company and then to auction off the assets, basically to the highest bidder.
Yeah, so if you don't do that, then one side or the other can sue the other for having taken IP which wasn't legally theirs.
Right. Yeah. I mean, you have to. You have a corporate asset. In this case, it was an LLC. You have an LLC asset, and it has to be, it's owned by the LLC until it's sold, and then it's a matter of who buys it and how much they want it. And it didn't have to be that way. And I will say, we sort of glanced over this one earlier. These days, a lot of companies people are going to LegalZoom and its brethren to form their companies. I hate to sound like I'm shilling for my profession, but I would do you a disservice if I didn't say to you that trying to form a company on LegalZoom, especially when it comes to this issue, the shareholders agreement or the LLC agreement, you can get yourself into trouble so quickly. This LLC that I was talking about, where they could only dissolve the company, it was formed on LegalZoom. They had a LegalZoom LLC agreement. There was nothing there to help them to sort themselves out when they got into trouble. And I mean, to be quite frank and blunt, they spent thousands and thousands of dollars, paying me and another lawyer to try to sort something out, much more than would have cost if they had just come to us in the first place and spent a few $1,000s to form it right, up front. Let
me jump back in, Paul, because we've been debating the LegalZoom question for the last couple of weeks, back and forth, the panelists, and I decided today to go on LegalZoom and form a corporation. And it was a pretty interesting exercise. I'll tell you, it's improved. It's better than I remember. And there are some elements of the LegalZoom process that are appealing. There are drop-down menus, for example, that cover all kinds of alternatives relating to business licenses that I referred to before. You think you're a software developer, but you're actually a broker-dealer. Well, LegalZoom does have a checklist that's pretty good. And it calculates the cost at the end, and it's less than the 4 digits that Paul mentioned. But he's absolutely right. It cannot make these decisions. If I go back one slide, it can't make the voting rights and veto decisions. It can't make the tiebreaker decisions. It can't make the buy-sell decisions. These are elements of, they're totally fact-sensitive, and they're elements of judgment. And I don't think the artificial intelligence of LegalZoom is quite there yet, although I will say I was somewhat impressed. Yeah.
So as a single co-founder, do I need this in place from the get-go, or do I need this when I get another co-founder?
I couldn't hear you.
As a single founder or a sole founder, do I need this? Or when I get a co-founder, then I should start?
Okay, well, the question is, I'm a single founder. Can I wait till I have a co-founder or a partner? It's a delicate question, but if you go back to the slides regarding the trigger event, I think our judgment is that you form earlier, not later. If you don't form as a single partner, you are a sole proprietor.
No, I meant about the governance and transfer issues, like.
Oh well, there are no governance and transfer issues. Essentially, if you're the only, yeah. Right, there's no need for a shareholder agreement.
But wouldn't it help to be a single member LLC for some liability issues and whatnot if you're a sole?
Yes, I think the question was, do I have to worry about transfer restrictions and governance provisions? The answer to that is no. Do I have to worry about limited liability? Our answer is yes from the very beginning, and maybe even before. Because you are entering into contracts, you are spending money, you're out there in this dangerous world. And we think that going out there with a single member LLC or a corporation protecting you is a benefit.
Yeah, I'd say on that point, there's a nuanced issue here. with a lot of the issues we're talking about here are set forth in the shareholders agreement or the LLC agreement. If you are if you're 100% owner of your entity and you're a corporation, you don't need a shareholders agreement. If you're the 100% owner of your entity and it's an LLC, then you still want a very simple single member LLC agreement. It's required in New York State. In Delaware, you're not required to have a written LLC agreement, but I think it's fair to say it's best practices to have one, in part because you do want to make sure that you maintain your limited liability shield. And part of how you do that is going through the exercise of having, and Frode had a slide about how you can pierce the corporate veil on a corporation. You can pierce the veil for an LLC also. And the way you make sure that doesn't happen, same thing. Don't mingle your accounts, have an LLC agreement, whatever the governance provisions are of the LLC agreement, and they'll be pretty minor, but make sure that you follow them. That's how you make sure you maintain your liability protection.
I want to come back to a point that comes to mind when Paul was talking a minute ago about the problems that arise from poorly formed companies that arise from disputes among founders and partners down the road, where the dispute resolution mechanisms have not been clearly agreed. I think another area that comes up in disputes down the road is disagreements over ownership. And the problem is that in the startup stage, before things get written down in paper, and they might be on napkins or or text messages or email, are vague statements about how many options you're going to get, or what kind of equity ownership, and maybe the vesting isn't really discussed, but maybe the guy who's offering the stock has vesting in mind, and the guy who's getting the stock thinks he's getting it. And this whole range of ownership issues often boils up down the road when the company is successful. It's easy not to fight over that 10% option that you were maybe offered, but maybe didn't get in writing until the company is worth something. It's being sold, it's exit, and then you come up with an email that said, of course, you've got 10%. And these are the kinds of things down the road that just haunt entrepreneurs. And in the early stage, when you're trying to sell your idea, you're out, selling. You're offering equity to everybody, which reminds me of another slide that we skipped over quickly. We have clients that are that think it's a good idea, and it may well be, to have celebrity spokesmen and fancy advisors and advisory boards, and this is often an important element of a startup company. And an enticement often is to offer stock to the celebrity. And we had one client recently who offered 50,000 shares to a celebrity. Well, he didn't have a corporation organized. He didn't know whether it was 50,000 out of 51,000 or 50,000 out of 50 million. And I don't think that deal is complete yet, is it, Aaron? Getting there. I want to spend a minute on the securities laws, because if there's one thing that you should walk out of here a little bit scared about, it's the securities laws. Notwithstanding all the trauma the country's been through in the last couple of years relating to securities law related issues, we still do have an excellent, well understood, and highly regulated system in the United States of governing issuances of securities. The statute is called the Securities Act of 1933. It governs, in fact, every sale of a security in the United States or using the jurisdictional means, which includes outside the United States if the United States is involved, every offer and sale of a security must be registered unless it's exempt. And if you sell a security in violation or offer a security in violation of that statute, you have to offer rescission. Rescission is very difficult to actually effect for lots and lots of reasons, and you don't want to do it. Now, the truth is, and we went through this fact situation earlier, there are exemptions for entrepreneurs and startups, but you want to make sure you properly qualify for the exemption. And it's another area where you can't use LegalZoom or your brother-in-law. It's an area that's fraught with risk. Illegal issuances of securities will kill venture capital interest, will kill an IPO, will kill the value in an idea, and it's very hard to fix an illegal issuance. It's like trying to go back and recreate something. You really can't do it. The cat's out of the bag. So be very careful. Once you get beyond talking about an idea with your partner, once you're approaching bona fide third parties, including friends and family and angels and anybody that you don't know, be very careful about securities law compliance. And you'll read, I just want to say, and you'll read in the newspaper that the Jobs Act has liberalized the issuance of securities. And it is true, there are elements that have not yet been reduced to regulation in the Jobs Act that will hopefully make our system of capital raising more competitive and easier. But hardly any of those provisions are actually enforced yet, and they don't change the basic rule, which is you have to register or be exempt.
So I think the takeaway here again is that there are exemptions out there that are relatively easy to comply with if you're working with a lawyer who knows what they're doing. And if you do it right in the beginning and you identify the exemption and you apply for it, you're fine. But I've had clients that have literally just started, well, they want to give some shares to their landlords. They just rip a stock certificate out of the book and write it in and hand it over. And they're selling some shares to their uncle and they rip out a certificate. That's going to get you into trouble. And it's not just a matter of whether you know them or don't know them. A friends and family round, it's the same thing. You need to make sure that you've identified an exemption and that you fit within it. And as long as you do, it can be relatively easy to get done. But if you don't do it right, then you may never be able to clean it up.
One of the reasons you can't clean it up is that the way the law works, if you do an illegal issuance, you either have to offer rescission or the stockholder can remain a stockholder, which really means that the recipient of the illegally issued stock has an option on your company. It's sort of like tails, he wins, heads, you lose. If the company is successful, he keeps the stock and gets the benefit of his stock interest. If the company's unsuccessful, he has a claim for what he paid, money back, and it is a personal claim. It can be brought against the promoter, sponsor of the company, the individual, you, who made the deal. So this really brings to an end my portion of the presentation. We have a couple of slides which we call teaser slides to hopefully incent everyone to come back for the next two programs, which are on financing and intellectual property rights. And Paul, you can either come up or I can flip to the financing slide.
Why don't I just come up and we'll... So on November 27th, we're going to go on to the next topic, which is now that you've formed your company, issued the equity to the founders, you've figured out what entity, what state you're in, everything else, how do you get the money to make it go? And this slide sort of identifies financing is often something done in stages. You'll, from the idea, once you have an idea, it may be self-finance, bootstrap. You organize a company, then maybe there's financing, it's friends and family. As you move on, you have an idea, you've executed, you've built a prototype. Maybe now you're doing an angel round of financing. Once you have revenues, maybe it's a Series A round of VC financing. So financing is often something that is done through stages. That's one of the things we're going to talk about the reason, about how you approach the financing and what the reasons are. The different type of financing: self-financing or bootstrapping, family loan or family equity, so friends and family, bank loan. Not always available to early stage companies because the nature of their business, but sometimes that can be possible. Angel financing, very prevalent these days. I'd say that's how many of my clients are getting financed early on, is through angels. Venture capital, the world of venture capital financing is changing. VCs used to primarily do rounds of not less than several million, but as those of you who are tech entrepreneurs know, as it becomes less expensive to start a company, you need less money, and VCs are finding that, although they want to write checks for $3 million, the entrepreneurs don't need $3 million. And so you have a lot of VCs these days that'll do a round for $250,000 or $500,000. So, I mean, there are a lot of changes happening in that world. That's one of the things we're going to talk about. Various considerations in financing that we're going to talk about. Is it going to be debt or is it going to be equity? People, if you've been down this road, you know that a preferred stock is often a way that a financing round is done. That's the traditional way of doing a VC round. An alternative is convertible debt, which is how angel rounds have often been done in the past. These days, at least I think many lawyers who do early stage financing, we're seeing a lot more deals done with convertible debt because of the smaller financing rounds that are being done. So we'll talk about that. We'll talk about how convertible debt is being structured differently with cap valuations. We're going to talk about different founder versus investor, or is it a self-financed or outside financed? What are the implications of that? When you bootstrap, you do it faster. You don't give up control, but it's slower. I tell my clients all the time, to the extent you can self-finance, there's a lot of benefit to it, but there are a couple of situations where you really want to seek outside financing. If you need to get to market quickly, or if your capital needs are intense, then maybe you're looking for outside financing. We're going to talk about the role of bargaining power in financing, how the economic needs of the business impact the financing, timing. We talked about staged financing, and we'll talk about dilution. How much are you going to have to give up along the way in order to get your company financed? So all of that will be on November 27th. Glen, do you want to talk?
Sure. So in our third session is going to be a session focused really on the intellectual property issues that are most important to startups. And so this would include issues like, well, what sort of agreement should you have with your co-founders in this area? What sort of agreement should you have with employees? What about vendors that you're hiring to build products or software or to perform services for you? We'll talk a little bit more about the trademark related issues that go in terms of selecting the name for your company, but also selecting names for your products and your services. We'll also touch on the topic of if you have a useful, new, or non-obvious invention, what kind of patent protection is available for that. And we'll also talk a little bit about what sorts of things you should be thinking about in terms of your customer agreements, website terms of use and user license agreements for mobile apps. There's lots of IP issues there, especially if there's any sort of user-generated content involved with your startup business.
Eric, do we have time to take a few questions?
Yes, but not everyone I'm sure can stay, so if you have to leave, we understand, but yes, let's do some questions.
All right.
Hi, you just I was told by my lawyer and my accountant to set up my entity as an S corp, and you guys sort of blew that off completely. And I'm wondering, what is it that about S corps that you don't like?
Frode? Yeah.
Well, yes, we did blow it off. Is your lawyer your accountant?
No.
Accountants love S corps, and I'm not sure why, and that's an exaggeration when I say that. Well, there are limitations on S corps. You have to be a U.S. citizen. You can only have 100 stockholders. You can't have classes of stock. So, for one, you're not going to have a venture capital investor in an S corp ever, because a venture capitalist is in all likelihood going to require a different class of stock, and that's not permitted. And I think we believe, this panel believes, and I think most practitioners believe that an LLC, frankly, is a more flexible structure to give an entrepreneur the benefits of pass-through treatment without any of the theoretical or potential downsides of an S corp. Having said that, for a simple business that generates simple income, an S corp can be an acceptable way to operate a business, and perhaps with slightly less legal expense involved in drafting and negotiating an operating agreement, because you don't need one for an S corp. You can try to use standard charter and bylaw provisions. But then you come to the shareholders agreement, which raises the issues of voting and veto and transfer, and all of those have to be dealt with either way, S corp or LLC. I think there are also some areas, some arcane areas, where New York State disrespects S corps, including in gain on sale. The city disregards the election, right? The city disregards the election. Yeah.
What about personal liability in S corp versus LLC?
Basically the same.
Oh, is it? Okay.
Yeah. But you have to, as Paul has said a couple of times, you have to adhere, you have to comply with the corporate formality rules.
Right.
And so you have to be adequately capitalized, you have to keep books and records, you have to keep the business separate from any other business. And that's basically equally achievable in either format.
Okay, thank you.
One other thing I would say, I wouldn't say the S corp is a wrong choice, and there was a time when we were doing a lot more S corps in this situation, but as LLCs become more common, that is a more prevalent choice. And as Frode mentioned, a lot of the structuring limitations you have with an S corp, you don't have with an LLC. So let's suppose you start as an S corp, and then you want to do a second class of stock. You want to do a preferred stock for an angel investor. Well, you can't do that second class of stock for the S corp. You can do it for the LLC. So that will push you from an S corp into a C corp. And if you had started as an LLC, you could have stayed as an LLC. When it comes, if you then have an exit, you've given up the benefits you would have had as an exiting from an LLC, because you got pushed into a corporation because you had to start a C corp because you needed a second class of stock. I mean, we're getting into sort of nuanced issues, largely of tax law, but those are some of the factors.
You were saying that these days VCs are attracted to LLCs, because that's one of the reasons why I was leaning toward an S corp.
No. What we said is VCs have traditionally only wanted to invest in C corps, and I would say that's still largely the rule. And I don't want the takeaway to be that VCs are investing in LLCs. What I said is, or VCs are broadly investing in LLCs. What I said is, we're seeing more flexibility on that question in terms of investments into LLCs. But by and large, I'd say the rule still holds. VCs are going to want you to be a corporation when it comes time for an investment.
Well, and a VC cannot invest in an S corp, because a stockholder of an S corp has to be an individual. And a VC, an angel may be an individual, but a VC fund is not an individual.
So let's go to another.
Again, I had an S corp, and the biggest problem with the S corp, and this was in the early '90s when we formed it, is the money that you earn in your year you have to take. You can't leave it and use it at another time, and that's a real problem, I think, with S. That's I think the number one problem, that you have money, you want to use it for your corporation, but you can't. You have to take it as
Well, you can, but you have to pay tax on it at the individual level and then give it back.
Wow.
In a corporation,
That's a big problem.
I would say the takeaway on this question is, don't try to figure this one out on your own. I mean, you should be talking to a lawyer and an accountant to get this issue answered.
Can I go back to the publication requirement in New York? About a year and a half ago, a friend of mine who's an attorney got up at the New York Tech Meetup and started trying to initiate a petition, I think.
Was that Steve?
Yeah.
Yeah, okay.
Missouri.
Right.
Yeah. And I'm curious as to, so many startups in the tech world are going to Delaware to avoid the publication requirement, which I actually helped a friend of mine, I'm an attorney, but I don't work in this area at all, form, and we use CSC, a third party to form it, and the publication thing cost $2,000 to do it. And I don't understand why New York, it seems like it's just designed to line the pockets of Cranes, of New York Law Journal, of the real estate publication, like 6 publications.
Well, it's throughout the state. I mean, and I agree with you. It's an issue that lawyers have been, lobbying the legislature to do something about, especially lawyers that practice in this space, because it's a problem.
Bloomberg, in all of his initiative in terms of tech and tech startups, would take a position on this somehow.
It ain't going anywhere. There's too much. It's supporting little publications all around the state on the backs of the startups. I mean, the news media, print media world is in trouble. This is a source of classified. I mean, maybe I'm being cynical, a little bit cynical, but not that cynical.
Continuing on this, if you form in Delaware, it's an LLC, but you're doing business in New York, aren't you obligated to qualify to do business in New York and still have the publication requirement?
Yeah, I heard that issue. We skipped over it, but yes, you are right.
Oh, okay.
If you organize in Delaware and you're doing business in New York, you still need to qualify and publish in New York.
So
and frankly, that's
going to Delaware.
For that issue, no, there isn't. In fact, it's more expensive to publish if you're out of state than if you're in the state by a little bit.
but all of the other advantages of the Delaware corporation, for example, the attractiveness to VCs, the flexibility.
LLCs.
Same thing. I mean,
well, a Delaware LLC is still a more attractive, to a sophisticated investor, is still a more attractive vehicle.
Yeah, I mean, let there be no question. Once we go through all the issues and the considerations and everything else, if you're a technology company, if you're expecting to take outside investment, if you're heading towards an exit sometime soon, you want to be in Delaware. You want to be in Delaware. There's very few reasons. Frode mentioned a couple of them, but very few reasons you'd want to be in New York, whether you're a corporation or an LLC.
Is that mainly for ease of use, or are there big tax implications one way or the other from New York to Delaware?
Frode went through the factors. It's the corporation law is better developed in Delaware. The Secretary of State's office is faster and more efficient. And you may not appreciate that issue now, but when the day comes when you're trying to sell your company or trying to take in a round of financing and you need to do an amendment to your certificate of incorporation, you're really going to appreciate that the Secretary of State's office is open until God knows what hour, and they'll do it like that. Whereas New York, it's like you send it in, they bounce it back, I can tell you, any corporate lawyer will tell you, you want to be in Delaware.
Paul, will you roll to the last couple slides so that we can officially finish? Because we have some fun slides.
Where are we
well,
going?
we can go. Yeah. Okay.
Yes.
So I went to a school that had a motto called Finis Origine Pendet. I never knew what it meant. It means the beginning shapes the end. And the more I thought about it for this presentation, the more I thought, you know, this is really what it's all about. If you do it right up front, it can have a huge impact, and you can be so grateful for the good foundation down the road. And, you know, in life we often skip foundation steps, and sometimes we get away with it and sometimes we don't. But if you put in place a good foundation, the likelihood of not being sidetracked, distracted, or even stopped is much less. It's, the beginning shapes the end, and I think that's what this discussion was all about. And then we have one more slide that shows where you end up. That's Warren Buffett, but it could be any one of us.
We have one question here.
So this pertains to both equity options as well as business formation. So I run an LLC that is not interested in VC funding and unlikely to bother to try and get that in the future. I understand that there's a lot of flexibility that's great with having equity options within the LLC, or if you are.
When you say equity options?
Or equity.
Okay.
My advisors and a number of other people that I've spoken with have been steering me towards forming a C Corp before offering equity to other new founders in the company. Are there advantages that I should be seriously considering within the LLC, or is there a particular formation that makes more sense if you are offering equity and not looking for VC funding?
Frode, you want to take that, or should I?
Let me make a quick observation. There's something called an incentive stock option, which has tax benefits. You can't mimic that in an LLC. And incentive stock options under certain circumstances, I mean, you can Google them, you can see the attractiveness of incentive stock options, which essentially defer tax on the benefit of an option. You can't do that in an LLC. Almost any other kind of lowercase o option, non-qualified option, you can mimic in an LLC. You can create, it just requires a lot of words, and it's less understandable by your potential employee who's got to maybe employ a lawyer to understand what you're trying to tell them. Stock options are better understood in general. So a stock option on a share of common stock is something that people can wrap their arms around.
And I would say easier. I mean, the equity incentive alternatives in a corporation are generally easier to structure than an LLC, and it's when and why to make that decision. It's very nuanced, and it really depends on your particular situation. I think I would agree with your other advisors that equity incentives and what that will mean for you is certainly one of the factors that you need to consider in terms of whether you stay in LLC or go to or go convert to a corporation. Or see, you are an LLC, you may convert. Is that what you said? Yeah. Yeah. I mean that's a meaningful factor to consider in that, but now you're a little bit further along, and so you're deciding. So now I'm an LLC. Should I convert? See, you're doing it the way I generally advise my clients: is start as an LLC, and then when the moment comes that there is a reason to switch, consider switching. And this is one of the factors that may make you want to switch. So.
Although I just want to say, if the pass-through treatment is really important for tax purposes, like really important, and you don't want, and there are reasons why you don't want to incur a corporate level of tax, you can stay with the LLC structure, and as long as you're not dealing with outside investors, which you say you're not, and you can structure something like an option or a restricted membership interest grant or subject to vesting, and mimic an option, create an incentive device that will motivate employees and or advisors or consultants or whoever you want to give the option to.
Yeah, I mean, there's no question, as Frode said, other than the ISO issue, the incentive stock options, there's, I do equity incentive plans for LLCs all the time that sort of mimic what we have traditionally done with corporations. So
it sounds like the legal expense involved in that is significantly greater than it is if
Well, if you're on an hourly rate, we didn't talk about fees, but all of you entrepreneurs should be aware that there are alternative fee structures, and there are ways to incent your lawyers to co-partner with you and go win-win with you, and maybe even do more work up front, not on an hourly rate basis, depending on what the relationship is unfolding and looking like, so yeah, inventing novel structures like equity incentive programs in LLCs generally cost more than granting a stock option on a share of common stock. But it shouldn't only be about legal fees.
So we'll take one or two more questions, then we have to wrap it up.
My question kind of overlaps with what we're talking about. If you have an advisor or a group of advisors, you might have one advisor that can find you some strategic funding, whether it's from a particular individual or a VC, but they're not a broker dealer. So they may want to vest with equity based on finding you $500,000. But if they're not, but we don't want to offset the securities law compliance. Is that possible for them to be vested with equity as a third-party advisor without a broker-dealer license?
Do you want to touch that, or?
Well, I guess what I'll say
You've all heard the Lehman model. A lot of people drive the Lehman model.
The long answer to that question, or I should say, the short answer to that question is come back on the 27th, and we will go into that at length. But I will say to you, as a general matter, when you are giving someone transaction-based compensation, that is to say a commission for finding you money, if that party is not a registered broker-dealer, then with very narrow exceptions, which generally don't apply, that will be a violation of the securities laws. Frode, do you want to?
Which, like a violation of the 33 Act, is virtually impossible to cure. So, and it's really bad for the unregistered broker-dealer who basically has violated the broker-dealer laws without having registered, and probably will never be able to register as a result. But it also can taint the transaction and make it unenforceable under the securities laws. But it's a real problem in the sense that there are a lot of finders out there who affect transactions in securities without registering as a broker-dealer, and it creates a nightmare. And there's some efforts underway to create safe harbors, but it's still a problem.
Yeah, it's a real problem. I mean, that's a conversation.
If that advisor is an employee of the company, is it a non-issue?
Well, that's what they do sometimes. They affiliate with broker-dealers. Oh, an employee of your company.
Of the company in question.
Yeah, well, then there are some exceptions for issuer broker-dealers. Issuer dealers.
If they're an executive of the company, it's almost like one of the founders who went out and got found $500,000.
Right.
That founder might be able to vest it with more equity because he was instrumental in, he's an executive.
I would say you still have to run the fact pattern by a lawyer because it's an area that's fraught with risk.
Yeah, I mean, we're now getting into a nuanced issue, and happy to talk with you about it afterwards. But it is very fact specific. Two more questions.
So, as an early stage startup, so I have an LLC and I have a website, both bought under my name. So how do I basically assign my website to my LLC?
Glen, you want to?
Yeah, sure. I mean, if you developed certain software, websites, graphics, etc., before you even created the entity, you could just do a simple, literally a one-page assignment where you basically said, I assign all the things listed below to ABC LLC, and there's appropriate language to do that, but it's not a complicated endeavor.
Okay, last question. Over.
Wow, talk about pressure.
This is the big wind-up. Knock it out of the park.
Well, I'm in the process of starting a business because I already have orders. So I'm really scrambling. And so this Delaware, New York issue is a significant one for me because I've been advised for an LLC. However, part of the orders that I'm getting is it's a manufacturing company. It's manufacturing with a small technology component. So back to the New York, Delaware standoff is I'm also probably going to be getting some government funding. Does it then mean that I have to register in New York for some, economically developed areas? There are different parts of the state where I might be able to get extra benefits. So I really need to register it properly right up front. Oh, and my favorite Latin phrase is nomen et omen, which is your name really determines your future. And I am designedinbrooklyn.com. The shortest URL you can practically get, 5 minutes.
Frode, do you want to?
Well, Jay, if you are talking to government agencies that may have requirements about where you're located or where you're organized, you just have to talk to those agency people and read their rules. If that's not a concern, then we fall back to everything we've discussed so far tonight, which is consider Delaware and New York, make a decision. Neither one will be fatal. Calculate the costs on both sides, and you'll be fine.
All right. Listen, I think Frode and his colleague Soren did a great job with this presentation. Let's give them a big round of applause. So we hope we will see you all back on November 27th, and then for the IP session to follow. Financing is the 27th. IP will be in December or January. Again, thank you very much, and we'll all be around for a while if there are any other questions. So.